look, I don't know how you could start at the beginning when the end seems to be the most important, because Garden State Equality versus Dow, which came down in 2013, which legalized same-sex marriage in New Jersey, is, one of the most important cases in the LGBT community in the state of New Jersey. But some of the people sitting here were involved in the predecessor case, which is Lewis v. Harris, which was also a very important decision.
Patrick?
It was fairly early in the marriage equality movement, and the Supreme Court, all 7 members voted in favor of the plaintiffs and indicated that they had a right to be treated with the same respect, dignity, and legal rights as married couples, but left to the legislature the question of whether to call the unions marriage or something else. There was 4 members of the court that said that. 3 members of the court indicated that marriage was the only way to satisfy the Constitution. So the court sent the matter over to the legislature and the elected branches to come up with a resolution, and we wound up with the civil union statute. So it was a half step towards marriage equality, but it did bring equal rights in theory to same-sex couples. We learned later through the Civil Rights Review Commission that, in fact, civil unions didn't really make the grade, didn't go all the way to equality with marriage. I was on the Civil Union Review Commission, and we did hear quite a bit. It was fairly soon after civil unions were enacted,
right.
And it was clear that the court had assumed that equality could be provided through this other vehicle, through civil unions, and it was also clear that it wasn't working. It wasn't the same as telling someone you're married when you're in the emergency room at the hospital. It means something different than I'm in a civil union, especially at that time when civil unions were a relatively new thing. It sounded foreign to people. They didn't know what it meant exactly. It sounded like you had to produce a certificate to prove who you were. When you say you're married, that's a universally understood term that very easily applied in situations. So.
And the other compelling, I was thinking about that, the emergency room situations, and the other compelling testimony that I recall were with kids and folks who, second parent adoption, whether they had any rights to children that were not a physical part of their union, but.
And you can see how the court might not have recognized that. I mean, at the time of Lewis v. Harris, only Massachusetts had recognized a right to same-sex marriage. No other state had. Very few other countries had anything in place. It was easy to presume if we have a parallel relationship, everything will be fine and everything will be equal. And if you just don't call it marriage, it will be the same. And in application, it just didn't work. It wasn't there. And then after Garden State Equality, it became very clear because the federal government was recognizing married same-sex couples, but not civil union couples. And I think one thing that's amazing about all of this is the short time frame. I know it seems like a long time for the litigants, but the change has been so dramatic in such a short period of time. It's amazing to see. If you look at other movements in civil rights, the arc is much longer. It's a much broader period of time to get closer to equality, and things are moving very rapidly. And you see that when you read Lewis v. Harris now, it's from 2006, the state of the world compared to the way it is now, just 9-10 years later, it's an amazing difference. It's just impossible to imagine that it would have moved so quickly.
I think beyond the marriage equality issue, I think, going back to your initial question, the fact that New Jersey has one of the best laws against discriminations in the country that protects not only sexual orientation, but based on gender identity or expression, which there's still only 19 states out of the 50 that protect based on gender identity or expression. And since 2006 it was passed, became effective in 2007, New Jersey was on the forefront of including gender identity or expression in its law against discrimination. So the fact that we've had this wonderful law in New Jersey for decades now in terms of sexual orientation and now in terms of gender identity sets us apart.
I think that's right. And also, in terms of setting up Lewis versus Harris, there were already a number of decisions that were very favorable toward some things that don't happen in other states now. Adoption, allowing gay parents to adopt. Those cases, I think, were very important and early.
They were. It did help lead the court to its conclusion, I believe, in Lewis v. Harris, that there were legislative enactments along the way that were fairly significant, that had really put together a public policy of protecting LGBT people in New Jersey, and it helps to have that legislative background when we've got a constitutional issue to be decided. But it's not over. Robin, we were discussing recently what the issues that remain to be resolved. Even if the Supreme Court were to rule in favor of the plaintiffs in June and on marriage equality, that's not the end of the road.
No, by no means. There's still other issues that we need to address and to get full equality for all LGBT people, including transgender rights and certain issues in terms of medical care, health care, homelessness. There's a tremendous problem with LGBT youth being out of their homes. So there's still a lot of issues to go.
In the course of clearing an opinion that another judge had written, we were on a 2 or 3 judge panel, the judge had used preference when dealing with sexual preference, and I had noted that I'd ask why use preference instead of orientation, as some people found preference offensive, because it's not a choice, it's an orientation. And my colleague was so quick to say, oh, I had no idea, and I certainly would never want to have connoted, any pejorative meaning. And so we changed it to orientation, and somewhere in the books it says orientation, not preference.
It's emblematic of how careful we are to try to make everyone feel comfortable and secure that they're getting fair treatment, to be sensitive to everyone's outlook on their life and the court system. It's very easy to cross a line you don't intend to cross by using what you think is ordinary language that someone could find offensive, and understandably so, and you haven't been educated to that fact. It's difficult to be sure that everything you say is measured carefully, and that's what we want to do. That's one of the objectives of the judiciary. It's having LGBT judges and staff members participate in that conversation assists in making sure that everyone is treated equally, and that unintended slights are not delivered to litigants and attorneys.
I just noticed that there's a program, I think this week or next week, on language and being welcoming to transgender folks in the judiciary, so that when people walk into courtrooms, that they are treated respectfully and nonchalantly, like any other litigant in our system.
The judiciary has gotten a lot more active in terms of training on LGBT issues, and in particular on transgender issues. I know whenever I speak on the issues, I've done the Judicial College twice, and one of the first questions is, how do we address somebody? What do we do? And the judiciary is truly concerned about it and sensitive to it, and they just need the information, just like you gave to your colleague in terms of sexual orientation, not sexual preference. The same thing with issues involving gender identity or expression. The courts just needs the information, and as far as I know, there's no transgender judges, so it's up to the rest of us in the community to kind of help educate, not because the judiciary doesn't know, but because they're not exposed to as many transgender people. They're getting there. It's becoming more of an issue in terms of, as you said, Judge, kids coming out at earlier and earlier ages.
Divorces. I mean, that's another area where that happens often. And every time that I have ever been involved at Judicial College, and we've done panels together, judges are genuinely interested in making sure that people in their courtroom come away that they were treated fairly and with dignity. And that's certainly one of the most important things. Obviously, somebody is not going to be happy with the decision that any one of us renders, but there is no reason that that person should not leave our courtrooms and our public courthouses not feeling that they were heard, treated fairly, and with the dignity and respect they deserve.